I'm Charlie Parness. I'm introducing the people that will speak here today. First, I just want to tell you on the procedure. After this presentation, between now and the end of January, I'll be sending out to each and every association, whether or not you're a member of CVE, 2 documents. One runs about 99 pages, the other maybe 70. The 99 pages is a complete set of documents for your building, if you want to use it. The others are particular sections, which will be, here's a section, here's why it should be changed, and following that, what it should be changed to. Okay? We can't do printed because the contract calls for just email addresses. Now, on emails, a lot of this information we get from the Office of Directors forms. If you haven't given us a change in your association, let's say change in president, change in emails, etc., please send me an email, cookve@yahoo.com. You know how to spell CVE? That's C-O-O-C-V-E. Very easy. At yahoo.com, and we will get it to the correct person. If your building does not have an email address, find someone in your building that has it, and we will get it to them. I want to make sure everyone's has. As I said, hopefully this will all be done before the end of January. Okay, anyway, by the way, questions also, we want questions, since we've got such a large crowd, only for people who are members of your boards. Okay? That's the only ones we want to ask questions. If any questions are there, that'll be handled by the people here. Now let me introduce the head of the committee that organized this thing. There's an area chair, Pat Barbero-Parda. And good luck.
Hi, I'm probably going to be repeating some of what Charlie just said. There is a one-page handout, so Michael's getting more copies made. And when they come in, if you could put them on the edge of the table, because several people in the audience do not have copies. It's just a one-pager. But I did want you to know, Michael Rackman is here from the committee I was on. Michael, could you stand? So our committee reviewed a list, an exhaustive list of condo lawyers and their firms, and ended up selecting 8 firms to interview in depth. And we used the same questions and went to each firm, and we ended up selecting Katzman and Chandler as the firm. We also wanted to make sure that the attorneys that did this work had the input of building presidents. So in the middle of the summer, late spring, early summer, Charlie and I sent an email to each association president asking, what issues would you like to make sure are addressed? Please remember, the 2 work products in this firm are voluntary. You don't have to do anything with them if you do not wish. There are 2 versions of the work products. One is the whole document, and the second one is what is being called spot amendments. Different options for things like being a rental building, what do you do with pets, issues like that. The attorney also is going to insert into our documents the latest changes from Chapter 718, which governs condos in Florida. The contract we have with the attorney's firm is that each building president will be emailed both documents, and as Charlie said, if the president does not have email, then someone else will be designated for that building. Thank you very much for coming, and remember, board members, when you come to ask your question, state your name and what building you're from. Bye. How do I turn this one off? Hopefully I didn't. Did I turn it off? No. You can still hear me. The handouts are on the edge of this table. Thank you, Michael. Can someone tell me how to turn this microphone off? Michael, can you? Did I press the
I hope so. Lord knows I spent enough time on it. Okay, there you go. Thanks. Okay. Excuse me. Okay, we're gonna start. Hopefully everybody has their copies now. Good afternoon, everyone. My name is Marianne Chandler. I'm with the law firm Katzman Chandler, and I assisted your fantastic CVE committee with the revision of a sample set of the association's governing documents. So, is this on, or I'm like, boy, you guys are saying I'm too quiet? My husband would love to hear that. He never says that. Okay, so I think Pat already went over this, but basically just to reiterate it, I want everyone to understand that nobody's being forced to do anything here. This is a completely voluntary project. If you receive the documents and you look at them and you may think some of it's helpful to you, to your association, you may think none of it is, or you may think you're just not ready to do it, or you may be gung-ho to do it all, which I hope. So whatever you choose to do, entirely up to your board, okay? Okay, so to give you an idea of what we did when we were doing the background on this, I want to give you an idea of what really comprises your governing documents. The governing documents of every condominium association in the state of Florida are made up of 4 different documents. The Declaration of Condominium, the Articles of Incorporation, your bylaws, and your rules and regulations. The reason that they're printed or listed there in that order is because that is the hierarchy of their importance. Okay, so your declaration is the most important document you have, and each document serves a different purpose. Your declaration really is the document with regard to use restrictions and anything that governs the unit itself. Your Articles of Incorporation really govern the corporate entity itself. And your bylaws kind of tell you how it is that you go about taking care of things such as meetings, what timing, when they're held, and things of that nature. Your rules and regulations, of course, govern everything from the day-to-day operations of the whole community. So when we set out to do this, we offered, the committee asked me to present 2 different options. One was a full document rewrite of the declaration, articles, bylaws. And the way that we did it is we decided to go through a set of sample documents that were provided to us. We changed and, basically when you amend a document, you usually strike out what you don't want in there and you underline what you're adding. So we did that in the manner that we thought best suited the document that was there. And what we also did was provided our comments with regard to those changes, as well as optional and alternate provisions. So what's the difference between that 2? The alternate provision really addresses an alternative way to handle what we already highlighted and changed. And the optional provision is something that you might want to include in addition to what we've already provided. Okay. The second option was spot amendments. So some associations may not want to amend their entire documents. Maybe you've amended previously and you're okay with it. So there may be bits and pieces there that you may want to choose. So what we did was we took out all of the amendments that we did and we listed those in spot amendment format. Also with commentary, optional, and alternate provisions. Okay, so moving on to some of the content of what we thought was most important, we're just going to hit some of those highlights of those areas. One of those items is known as Kaufman language. And for those of you that aren't familiar with Kaufman language, what Kaufman language does is it's actually, the term Kaufman language refers to those words there, as amended from time to time. And basically there was a case by the name of Kaufman that came out where the court basically said, if you do not have, if your documents don't have language that says that your community is intended to be governed by the provisions of 718 as amended from time to time, then your community is basically stuck with the declaration, or, I'm sorry, the version of the statute as it existed on the day that your declaration was recorded. So that's significantly important to everyone because over the years, each year, there's statutory changes that may very well benefit your community that you may find yourself unable to enforce in your community or apply to your community due to the lack of Kaufman language. So that's something I would highly recommend adding, and that's one of the changes that we already put in. Okay, so with regard to your common expenses, this is another area that we thought there were items that should be changed. Whenever any one of your communities that has items such as social gatherings and events, maybe holiday lighting, or maybe at your board meetings you provide coffee and donuts. All of those things have to be specified as common expenses of your community, or technically they are not, and you should not be using association funds to handle those matters. Maintenance and repair is always a very big question that we get, I'd say, several times a week, really, in our practice. And unless your documents clearly define for your community exactly what items you wish to be maintained by the owners and which items are specifically to be maintained by the association, you may run into some problems in that along the way. So there are certain items that you definitely want to address there, such things as windows and doors. Many times documents are silent in that regard. So those are things that you'll want to look at. With regard to parking spaces, some of you may have assigned parking spaces, then those become limited common elements to the unit. If your documents contain provisions, the statute says if your documents contain provisions that allow those to be changed, then they can be. But if your documents are silent, that's appurtenance to the unit. It has to remain that way. So you may want to, that's the exchange of use rights. You may want to allow that exchange of use rights if that suits your community. You may also want to make some specific rules with regard to unassigned parking spaces and how you wish those to be handled. So parking spaces are always a big issue in communities, so that's something that we touched on as well, provided some our commentary and recommended amendments to your documents. Parking restrictions, such as the number of vehicles that can be owned by one unit, the type of vehicle, commercial vehicles, or size. Some communities may have size limitations for certain vehicles. How exactly you want parking enforcement to take place. If your association wants the authority to tow a vehicle, that has to be contained within your governing documents, and of course is also governed by the provisions of statute, so any towing company will post the proper signage and things of that nature. Let's go back there for 1 minute, I'm sorry. A parking program. If you want to institute some sort of decal system for your community, you can certainly do that as well through your documents. Sorry. Okay. Guest occupancy and age restrictions. You are a 55 and older community. You want to make sure that those provisions are in line with the current version of statute, both state and federal, with regard to housing for 55 and older. And also, you want to make sure that you have some provisions that govern guest occupancy. The reason that I say that specifically is because I can tell you, I know that some of your buildings are non-rental. If you want to enforce a non-rental provision, you always have to, it's only as strong as the ability to enforce it. And I can tell you in my experience over many years, many times when I send out a violation letter that says you're illegally renting your unit, we'll get back a letter from that person that says, no, that's my guest. Items such as short-term rental are also an issue. I don't know if we have a separate slide for that. No, it doesn't look like we do, so we'll go back to that. Okay, so short-term rental, I know there's a lot of issues going on right now with Airbnb and things of that nature. We added some provisions in there that are relatively novel, and we think that they, we believe they would be enforceable, and it will help you significantly to address issues of short-term rental, particularly on websites such as Airbnb, Vacation Rental by Owner, and I'm sure there's a million of them out there. You want to make sure that, and we wanted to make sure that your documents are not only updated, but that we give them the ability to change with future changes in the statute, so that every 2 years or so you're not you're not facing a situation where you go, oh, I have to amend again. Okay? That's really gives you the best bang for your buck, so to speak. So you want to address things, first of all, with regard to satellite dishes. You want to make sure that they're up to, that your provisions regarding any type of satellite dish are up to the current FCC codes, and we've already added that in. With many people these days operating businesses from home with computers and things like that, you may want to allow, a lot of your documents will say you can't operate a business from the home, and of course many times that's exactly what you want it to be, but you want to allow people to telecommute and to have that ability maybe to run, maybe their own small practice through a home computer or something. And so we put restrictions in there regarding home offices, and you just need to, we added provisions such as it can't increase the foot traffic, you can't post any signage, anything of that nature, but it gives a little bit of leeway for people to at least telecommute. EPVs are the new electronic vehicles, and I'm sure every day that you drive around, you see more and more of those on the road. There's nothing specific to them now within 718, but I imagine and anticipate that within the next few years we'll start to see requirements for condominiums to add charging stations. So what we've built in is at least the ability for you to do that in the event that it becomes an issue for you or it becomes statutorily mandated. Pet restrictions. This is always a hot topic amongst communities. If you had, we looked at your pet restrictions, we changed them to encompass both pets and animals. You can add provisions with regard to maybe you want to, if you do allow pets, then maybe you want to have things such as weight restrictions, a restriction on the type of breed, a dangerous dog provision, or dangerous animal provision, I should say, and a limit on the number of animals that you can have in a unit. None of those items will specifically apply to service or support animals, which is an entirely different topic, but we do highly recommend that every board adopts rules and regulations governing service and support animals, so that every person that needs to apply for one that knows the proper channels that they need to go through, and it gives you some latitude in terms of knowing, at least controlling the process. Smoking is another issue that's come up in the last few years, and within the documents we've given you the ability to ban smoking or prohibit smoking within the common areas. We've also added optional provisions which will actually prohibit smoking in the units. It is possible to do. If you choose to do it, you must grandfather in the existing, and there's a method to do that. That's also some background information on that's also provided. Yeah, rentals, whether you choose to be a rental or a non-rental building. If you want to be a rental building, then you have to, you want to specify provisions regarding the time period. You may want to consider putting items in such as a waiting period. It could be, I've seen them anywhere from 12 months to 36 months from the time that you purchase a unit in the community to the time that you can rent it, so that you don't have, if in the event, heaven forbid, that we have another crash, you don't have a huge investor type insurgence into your community. That was Airbnb. Hold on, let's go back one more time. Let's see if we covered that. Oh, screening and approval for tenants. If you do allow rentals, we strongly recommend that you add, if you don't already have it, screening and approval rights that contain specific criteria which will allow you to disapprove for good cause. Those are very important items to have. It's also equally important to have those for purchases as well. I think we're good. We did Airbnb. Okay. Well, there you go. Purchasing restrictions. Of course, again, you want the right to approve or disapprove for good cause, any applicant. If you allow corporate owners, and you may choose not to, again, that would include a grandfathering, but if you choose not to in the future to allow corporate ownership, you certainly want to carve out some provision or some ability for tightly held corporations as well as trusts and things of that nature, so that you won't stop people that want to put their property in a trust, for example. And if you do allow corporate ownership, you want to make that corporate ownership contingent upon that owner designating one primary occupant to occupy that unit. This way you have screening and approval as well covered, and it kind of helps you to prevent a situation where somebody purchases a unit under a corporate name and then uses it as an employment perk to run people in and out of there all the time. You can include also, we've touched on items such as minimum down payment requirements for any purchase, and the escrow of maintenance payments. Anywhere, we've given some suggested timeframes and things of that nature within those documents. With regard to your approval criteria, you will always include a criminal background check. With regard to the financial background check, we can limit approval based upon FICO scores, and we could have minimum income requirements as well. So those are items that are discussed in there and addressed that you may want to consider. Foreclosure and collections, that's always a big area as well. If, first of all, if your documents haven't been updated or haven't been amended throughout time, chances are that your rate of interest does not match the current statutory maximum. So we want to at least allow you to do that and bring it up to date so that you're not limited there. If you are, the right to collect interest on a delinquent account is statutory, but the right to collect late fees is not. It must be contained within your governing documents. So we've added those provisions and brought them up to the current statutory limits. Mortgage subordination protection. Now, that is a particular area that we talked about that is affected by Kaufman language strongly right now. Many of your documents, and your documents in particular, contain some language that basically allows somebody to purchase a unit at a bank sale and not be responsible for the prior past due amounts to the association on that unit. Kaufman language will help you with that, but we also went in and changed that specific language to protect you further so that it doesn't even exist in there. With regard to bank sales, these are things that sometimes many times there's not much that we can do to amend. Thank you so much. Many times if you want to change the rights of a lender with regard to their foreclosure sales, many times that requires mortgagee approval. So if we run into that in any particular set of documents that you may have, then we'll address that, and there's ways to write around it so that we don't need to do that. We can basically just kind of carve them out. Or there's also a statutory process to obtain approval. So those are things that we could talk about. Your covenants and rule enforcement provisions. Practically every set of documents I've seen, including yours, have the right to collect prevailing party attorney's fees. So in the event that you have to enforce the provisions of your documents, you have the right to, if it goes to litigation and you succeed in that litigation, then you have the right to collect attorney's fees that were incurred by the association from that owner. What happens many times is maybe the association sends out some letters and the owner doesn't comply, and then maybe they get the law firm involved and the law firm sends out their letter, and at some point prior to litigation, the owner complies. When that occurs, there is, unless you have the right to collect pre-litigation fees within your documents, and you do not, those monies expended fall back on the association and every member of the association. So that's a definite, very good provision to add. We've already added it in, so that's one of the things that we addressed for you. Moving on to your articles and bylaws, which is really where we are here. That kind of concluded the declaration. These next sets of changes pertain to mostly the bylaws. Whether or not with regard to your board of directors, whether or not you intend your board of directors to all be unit owners within your community, okay? Unless you specify that, that will not be the case. Then anyone could sit on your board. You may or may not want that. You may want to add provisions that there are situations in which, let's say you have 2 people that own a unit, but only one, 2 people live in a unit, I'm sorry, only one is actually the owner of the unit. So maybe it's a spousal situation, maybe only your wife's on the deed, maybe only your husband's on the deed. But you may still want to allow that other spouse to run for the board. We can carve those things out, and we've addressed those in the optional provisions. The number of board members that sit on your board. What you may want to do is either give it some latitude, so that you can build into your documents a method of changing that, or you may want to set a hard number for the number that you feel is appropriate for your community, and those things are addressed. With regard to board compensation, if your board members are going to be compensated, it must be contained in your documents. So that's something you will definitely want to look at. With regard to board powers, the 2 main things that I always look at and consider is you should have the specific right, your board of directors should have the specific right to levy special assessments. If that's not there, we've added it in, which we have already, and the ability to borrow funds. So those are 2 items. You do, if your documents are silent, you still have the authority to borrow funds based on the non-for-profit statute, but it's always better to layer it in and make it very clear where you can. So we would suggest adding that. Second. Okay, with regard to your annual meeting, the date, time, and place of your annual meeting is addressed in your bylaws, okay? And many times it's a very strict, hard date, okay? So maybe it's the 2nd Tuesday in January at 8 o'clock. And that may or may not be suitable. So what we've done there is we recommend a little bit of latitude, saying that perhaps a provision such as the annual meeting must be held not less than 10 or more than 13 months after the prior annual meeting. And of course, there must be one every year. So those are things that we can loosen up a little and give you the ability to govern your association without being held to very strict deadlines. With regard to the annual meeting in particular, when you have a strict deadline like that, you're almost backing yourself into a situation where, through no real fault of your own, you may be in violation of your documents. Let's say, for example, it's the 2nd Tuesday in January, and your notice goes out late, and you have to renotice it in order to meet the statutory time frame. Well, that's always more important, and it's what I would tell you to do. But if you loosen up that provision, you won't be in that situation that you're automatically in violation of your documents. So that's something that I recommend. Your membership meetings, your quorum. If you have a problem meeting quorum and having a meeting so that you can get things done in your community, we may consider lowering that quorum. That's something you can consider doing. Your notice requirements, where they weren't in the documents we were provided, where they were not compliant or where they didn't mirror the statutory notice requirements, we change them to match. You can have notice requirements in your documents that are more restrictive than the statute, but you can't have notice requirements that are less restrictive. So if the statute sets it, it's always best to kind of go with that. So we've done that. And with regard to proxies, some documents have restrictions on the number of proxies that can be held by any one person. You may or may not want to keep that. We've addressed that, and that's an issue you may want to consider. With regard to amending documents in general, and this applies to your declaration articles and bylaws, if you have a very high threshold now and you say, hey, Marion, I don't think that we can get that vote, then what I would recommend is that you use a two-step process. We can go in first and amend the method of amendment. It's still going to take some legwork. It may take some calling, some phone calls, some going door to door to get that passed. But once you get that passed and it's a more reasonable threshold, then you'll have a much better time passing everything else. Okay, so this is really more or less talking about the process of amendment itself. So once you've decided what you want to change, you have to make sure that you have the proper language. So this is now going to be done on an association by association basis. Again, we worked with a model set of documents. Some of your communities, they may not exactly mirror your documents in particular because you may have had amendments throughout the years. It's my understanding that the base documents were all very similar, if not totally, if not identical. But again, you may have had amendments through the years that changed some of those provisions. When you amend, again, what we discussed earlier, you typically strike out what you're deleting, you underline what you're adding. If you're doing a full document rewrite, or you're substantially changing a particular provision, that requirement doesn't apply, and you can just have a clean new language type of document with that disclosure that the language has been substantially changed, and it refers you back to the original provision. If you're doing a document, if you're going to go ahead and do a full document rewrite, then you're going to see that red line document go back and forth. And typically what we end up with is a document that's no longer red line, but it's red line, blue line, green line, going back and forth between the law firm and the association. So I never recommend that that's the document that you send out, because now it's in multiple colors and it's very confusing for owners to read. And on top of that, whatever you approve is what you have to record in the public records. So if you're doing a full document rewrite, my recommendation is to present a clean document to your membership, make the red line document available if they wish to take a look at it, so that they could see specifically where the changes are. If you're going with a full document rewrite, or even spot amendments, but mostly the full document rewrite, this is important, I always recommend that you include a cover letter that in plain language describes most of the changes that you've made and the reason that you've made them, so that it's easier for people to understand, because many people are not going to read every single word of, I believe, what's now somewhere 100 pages for the full document rewrite. That's it, we're done. I'm sorry, I didn't introduce Bill earlier. I know many of you know Bill Rappan. Bill heads the educational division of our law firm, and he handles a lot of classes and gives free classes on many different matters. You could always go to our website if you're interested to see what his class schedule is. It's katzmanchandler.com. Bill's going to be here on March 14th for a board certification class. So if any of you are interested, you could register for that. That would be great. Now, I guess, we'll open the floor up for questions. Okay. Yeah. Yeah, board member questions. Okay. Yeah, if you guys could just come up to the microphone, and if you could tell me just what board you're on.
I'm Nicole. Oh, is it open? Is it open? Yeah. If we make changes, does it have to be approved by all the owners? It's closed.
I think what she's asking is if they want to make any changes based on what we've provided them, or any association, does it require a vote of the membership? The answer is yes. It does require a vote of the membership. The specific threshold will depend upon your documents. And you must amend, again, you must hit that threshold even if you're going to lower it for the future.
Okay, and my second question is, you didn't speak at all regarding the hardship. Even though if our building is a non-rental, is it true that hardship it's over and above our rules?
Okay, so if your governing documents today, if you are a non-rental community and your governing documents contain a hardship exception or allow the board to grant a hardship exception, then I would strongly recommend that the board adopts rules and regulations that specify what constitutes a hardship, okay? If they haven't done that, that's something that they definitely should do. I'm going to tell you, in my personal opinion, if you're going to be a non-rental community, then I would either specify in the declaration what your hardships, what constitutes a hardship, but really, hardships are so subjective that I would recommend taking the hardship provision out. There will always be certain avenues in which the board would have to comply and allow that, but generally the intent of your community, if you're a non-rental community, the intent is for there to be no rentals. Okay. And it really, it muddies the water when you add a hardship with, undefined.
But is it a Florida rule? Is it a Florida rule or?
That you have to have a hardship exception? No.
No, okay, thank you.
You're welcome.
Hi, Beverly from Westbury G.
Hi.
I have two questions.
Okay.
One is, we have a legible copy of our declarations, but nowhere, none of our owners, I couldn't find it through our old attorney, we don't have a legible copy of our bylaws, which is so important. Would you be able to provide that? Where would I get that?
Right. It may be, it's possible that your bylaws weren't recorded. If they were recorded and you're saying there's just not a legible copy of it, if the copy that, if the copy that's in public records, sometimes if you pull it off of the system, it's difficult to read, but sometimes if you do it, if you actually go through microfiche, for example, back through the courthouse, you can get it.
And where would I do that? How do I do that online? Because Bailey Woodruff, they were going to sell me a copy. It's the same copy that we've all had that nobody can read. It's not legible. It's all blurred.
Yeah, if it's a printing problem, then you could go to the public records and you could pull up the OR book and page where it is and see if you could read it that way. If it's legible on the screen, then it's a printing issue.
Okay, yeah, no, it's not. We haven't been able to find any legible copy of our building. So if you were,
you amend them and restate them then.
Okay, and this is what you're talking about. You could do that in this package that you have for us. I mean,
well, if you go with a full document rewrite, that's exactly what we would be doing. We'd be amending and restating those documents, including
but you'd
bylaws.
have to be able to read it.
Well, in this case, if you're doing a full document rewrite, basically we're going to say that these bylaws will replace and supersede any prior.
Thank you for that one. The other one's a simple question, is what are the charges for, is there a basic charge for all this package, or if you just want the bylaws?
Okay, so what I'm offering to do, basically, at this point is, I will have anyone who, after you've gotten your documents, anyone who's interested in proceeding, I will provide a free consultation with you to go over what it is that you wish to change, and understanding that we're going to have to look at your documents, and it'll be better to do that one-on-one and see how much is involved. If you had 30 amendments through the years, it's a little more work than somebody who has never had an amendment, okay? And then you'll see the way that the documents are structured. There's so many options and choices there that we need to sit down with you and figure out what it is you want to change.
Okay, thank you so much.
One thing I will tell you is that based upon the significant number of hours that have gone into this project and the time I've spent with those documents, we will definitely offer you an excellent price, a very discounted price to do any work that you're interested in doing.
Thank you.
Well, it's very difficult to even give a ballpark because I don't want to overquote you. You know? I'm sorry. Please do that. Okay.
That was basically I'm with Mr. J.
Come up to the microphone, please.
I'm president of Mr. J, and my basic question is the same. Some ballpark estimate in terms of what the cost would be if we had a whole document rewrite, for example. You know, a range.
Yeah, I mean it's difficult. I would estimate, if I had to estimate, I would say if you're looking at your declaration or like a full rewrite of everything, you know, I think you're probably in the $500 to $7,500 range.
Perfect. Thank you.
Okay? Thanks.
Hi, I'm from Richmond E, and I would like to know a few questions. Are you allowed to take a fee? Is the building allowed to take a fee from the people who rent?
What type of fee?
In other words, there's a certain processing that we have to do in order to have renters, and it's taking a lot of time from the president and other people in the building. The question is, is the building allowed to take a fee for that?
Okay, so your documents have to provide for screening and approval, and then if you have that screening and approval, then you are limited to $100 per applicant.
So you can't go above that?
That's correct.
Okay. The other question is are the rules different for renters than they are for purchasers?
They can be, depending upon what rules.
In other words, let's say the objective is if an individual was a renter and they proved to be a non-asset to the building, they did things that were wrong, etc., they weren't friendly, they were noisy, etc., can you reject them because of that, or is it limited, as it was before, to somebody not having a good credit record or to being a felon?
Oh, no, that is included within the list of criteria that we generally include. We do include items such as evidence of negative conduct or bad conduct at other associations or at your own association during a prior rental.
And then you could stop somebody from renting if they...
Then you would disapprove them. But what you're going to have is you're going to have in your documents the right to approve lease renewals. So that's the big item you want there.
Terrific. Thank you very much.
Hi. What I'd like to know is is it actually legal for us to put in our docs that we are a non-rental unit? Because from my understanding that Florida law indicates that it's not legal to have a non-rental.
Okay. So if your building is a no-rental building and and has been a no-rental building, then there's nothing wrong with that provision, okay? If today or any time post-2004, really, you were a rental building and you want to become a non-rental building, okay, then Florida statutes has a provision that basically says that wherever you're looking to limit the term of a lease, which you would be doing there,
right,
okay, or further restrict leasing, then those types of amendments only apply to owners taking title after the effective date of the amendment and any current owners who agree to be bound. You agree to be bound by voting in favor of the amendment. Okay?
Thank
you. If you want to become no rental, and you are rental now, you want to become no rental, it is possible. It's a process. It's going to take you a couple years to get there.
Okay. Thank you.
You're welcome.
Hi. I'm president of Westbury L. My question is, if you call a meeting for the board of directors that they have to make a decision about the building, A, how much notice do you need to give the board? B, does it have to be posted, or can you just speak personally to the board member? And C, do you have to make the building, other people who are not on the board, include them in the building or have the option for them to attend if they want to?
Okay, so with regard to board meeting notices, Florida statute says if you're going to have, except in very specific circumstances, if you're going to have a board meeting, you have to notice that board meeting at least 48 hours in advance.
Okay.
That includes, it's a formal notice with an agenda. It's posted on the common elements in a place designated by the board, wherever it is that you put notice, okay? With regard to notifying board members, some documents have, and I can't recall off the top of my head if yours did or not, have, and I think they did, had a longer time frame to let to notify board members.
Right.
So some documents will say 3 days notice to a board member. In those cases where we're changing, we're saying we've changed those to match the statute because it doesn't make sense to have a 3-day notice when the statute says 2 days, okay? There are circumstances in which you need longer notice, wherever you're adopting rules and regs governing the use of the unit, wherever you're levying any type of assessment, your budget meeting, okay? All of those require a 14-day written notice that must be posted and mailed to every owner, okay? The only other thing, there was one other thing I wanted to address.
Right, if a board meeting making certain decisions, if you have to notify the rest of the people in the building.
You do.
And you do?
You do, you post notice.
Okay, and
48 hours in advance.
Right,
can owners have the right to attend a board meeting, okay, and discuss and speak on any agenda item, unless it's one of those areas governed by statute that says you can have a closed meeting. Personnel issues, legal, pending or threatened litigation, where your counsel's present at the meeting.
Thank you very much.
Hi, thank you for your clear presentation. Maggie Batchelor, Oak Ridge F. Assuming that we may do a full document rewrite, what would be the procedure for pulling out hot button issues to vote on separately?
Okay. So if you do a full document rewrite, and that's something I should have actually already touched on, I always recommend, when we sit down, we're going to talk about, things that are going to be hot button items. And my recommendation is always that we approve as much of the full document as possible, okay, that won't be hot button. We pull those hot button items out on the same proxy, we vote on them separately, with notification to the owners that in the event that those items pass, that they will be integrated into the text of the full document, assuming the full document passes, prior to recording. This way you're only making one recording. Okay?
Thank you.
You're welcome.
Hi, I'm Joe Friedel, Grantham A. The documents that you're going to be giving us, will they show the existing model that was used to make the changes and then show the changes, or are we just going to get a new set of documents?
No, the underlying text is of the exemplar we were given is there. You're going to see the redlined version of it, okay? And I never recommend maybe this is a good time to say this. There very well may be, and I know that there is, attorneys out there that will give you, okay, you want a doc review, here's a new document, okay? And they could do that very inexpensively because they have maybe one form document they use, okay? When I do a document rewrite, and this whole project is premised on the idea that it's always best to start with your original document, because when you start moving things around just for the sake of moving them, people are suspicious. They don't know, why did you move this from here to here? And there's really no reason for it. Unless there was a specific reason to move a section of provisions out or to another area, we left the document intact. So I think you're going to find that you recognize the document. It's familiar to you, okay? And it's going to help you to understand where those changes are.
Thank you. That's what I was looking for.
Be careful of anyone that's offering to do things for you, in a unreasonably inexpensive way.
No, I'm just looking to how I'm going to look at it.
Okay, yeah, no, and I understand. I'm sorry I used your example, but it would seem like a good time to bring that up. So
thank you.
Okay, thank you.
Hi, I'm Paul from Upminster M. My first question concerns whether or not you've put anything into the proposed documents for enforcement of the rules.
Yes, okay, so basically what we did is we went through those documents, and of course, we added some items for enforcement. You'll see that. All I did here was pick like the major highlights of things. So, of course, within your enforcement, we also added your right to pre-litigation fees, okay? And there were some other things there that basically, would benefit your community.
Would that include fining people for not following the rules?
Fining is included.
Right. Second question is, in your slide presentation, you skipped over a line item that called for purchase of a second unit in the same building. Were you aware you skipped over that one?
I wasn't aware of it, but...
What would you have said if you didn't skip over it?
I'll go through it quickly. If you want to have a restriction within your documents that limits the number of units that could be owned or held by any one person or entity, we can include that in there. So that's one of the optional provisions.
But the present documents do not address that, do they?
I don't recall. I don't think they do. But if they do, then we made our edits to them and commented on it.
Okay, thank you.
You're very welcome.
My name is Bob Wallers from Oak Ridge F. The question is regarding concerns about financial. The question is regarding financial concerns about owners, and you mentioned you could put a down payment requirement on it, but one concern that we experienced in the downturn was that people had taken out in mortgage a loan based on the value of their condo, and all of a sudden they're underwater because they can't pay for it. We have a situation like that now, possibly, where we're concerned that somebody's going to just take advantage of the system and not have enough money, but they're buying someplace else, and then they're going to leave us stuck.
Right, and that's a difficult situation to deal with, because even some documents have minimum equity requirements, but they're very difficult to enforce if the market gets turned on its head. So one of the things that I would recommend is to include the escrow of maintenance payments. Because what that will do for you is at least let you know that you have X number of dollars on every new purchase. You have X number of dollars in terms of maintenance payments that are being escrowed in the event that somebody fails to pay. And you run into that situation. And then you can list the criteria upon which those funds can be drawn. And we usually also include, if they are drawn upon, the obligation of the owner to replenish them.
Is that something you included in these documents?
That is something that's in there.
Okay, thank you.
Okay, you're very welcome.
Hi. Jim Negley, Durham S. I have two issues. One is somewhat bizarre language about when we refuse somebody. There is either for rentals or purchasing. There's some bizarre language about substitutions. Is that part of 718, or is that in our documents?
No, that's document driven.
I don't think any board would want that.
Well, I took that out, and that was my recommendation, but you'll see the commentary next to it with regard to that. Now, you may very well want, as a board, the right of first refusal. Basically saying somebody's going to come to you and say, I want, here's my contract, I'm going to sell my unit, here's my contract. Maybe it's, maybe it presents a situation in which you really don't have criteria in which to disapprove, but, sometimes there's maybe some deals that are going on where the unit's being offered well below market value or something like that, and the associations can step in and say, exercise that right of first refusal to step in and purchase that unit.
Okay. As
if, they basically just step into that contract.
Because the way we feel now is almost like we can't refuse anybody for anything,
Right, and that's really that's the situation you're in if you don't have the separate disapproval for good cause. language, and you have that language in your documents that say if you disapprove, you must provide a substitute purchaser, you're kind of boxed in, because you probably don't want to purchase it. So where it was required to provide a substitute purchaser, that's been deleted. Okay.
My second issue is that some of this archaic stuff that's in there, I mean, can you provide maybe, like in 1982, we just had a general update, and most of the units, most of the buildings actually adopted a bunch of really kind of standard. So could we have something, will you produce something like that so it'll be like economical for almost every building to kind of adopt a whole set of things that are more, current to the environment today?
I'm not sure I understand.
In 1982, we had pretty much all our documents were, they hired somebody, I believe, and most of the buildings adopted a bunch of these amendments. One of the amendments, for instance, was actually you could rent any time here, and when it was you couldn't rent for business purposes. But there was a whole bunch of things.
Okay.
Could you just have like a bunch of minimal standard things that we'd want maybe so that we could do it at an economic?
Well, I'll tell you what. Again, I'm more than willing to meet with you without charge. Okay, and.
So I don't want. I'm not talking about an individual level. I'm talking about maybe at a.
It may be if that's the situation. If you go through, you'll see. If you go through those and you could say I want A, B, C, D, and E, then I could create a package price for you that's very economical. I've already done the legwork. Now it's the tweaking. So I do feel you may hear other prices out there again. You may hear things like that. I have a lot of familiarity with these documents, so
So it won't take. It'll be free and it'll be pretty quick. Okay. All right. Thank you.
Okay. Thanks a lot.
Hi, Ed Hack, Newport U. I'm really asking for clarification about this business of a building voting to become a non-rental building. And I wasn't really clear about what you said about folks who've been renting. Are they grandfathered in, or what's the status of people who have been renting up to that time?
Okay.
One more time, please.
So if you allow rentals and you now want to move to a non-rental structure, okay, then those types of amendments, according to statute, only apply to new owners who purchase after the amendment's approved, okay? And the current owners who agree to be bound by the amendment. Now, if you're currently renting your unit, but you're going to agree to be bound by the new amendment, then that rental term will continue, and at the expiration of that, you won't rent any further.
Right.
If you don't agree to be bound by
You
it,
continue to
then
rent.
you continue under, as if you're still under the old documents. Does that make sense?
Yeah, it does.
Better?
I don't see it being satisfactory to the people who don't want a rental building anymore. I mean, it's a curious loophole.
It happens over time, It's something that really, eventually, one by one, as people sell, eventually you become a non-rental building. It is a lot of upkeep. I'm not going to, that's for the board, for management. It's a lot of record keeping. Because you have to know who voted, who didn't, who voted yes, who approved, and where your current rentals are and how they expire.
I understand.
But I've seen it happen. It takes a number of years.
Okay, thank you.
To be fully non-rental.
Right, thanks.
Okay.
In the complete rewrite that you did you remove all of the paragraphs and pages concerning the development, first board, etc.?
Yes, wherever there were references to the original developer, we took those out. If the entire paragraph was unnecessary, we took it out. If there were provisions in there that needed to be addressed, they were rewritten.
Okay, and one other question on the rental issue. We've been told that people cannot get a mortgage if more than 20% of the units are rented. Now, even though our documents don't currently say anything in reference to that, do we have to amend to do that?
If you want to put a cap on the number of rentals, then you have to amend to do that, yes.
Okay, thank you.
You're welcome.
Pat O'Donnell, Farnamo. Marianne, have you done any work on making sure that the declaration, the articles, and the bylaws all agree? Or is there a list, if you adopt this amendment, it must be in the declaration, and the same amendment must also appear in the bylaws? Or the articles?
Those are in the comment sections. So I thought that if there was something that you were taking out, you know, or changing in the declaration that I felt affected another document, then there's a comment to alert you to the fact that you've got to go back to the other.
In a comment?
Yes.
Okay, thank you.
You're welcome.
My name's Dwayne Gill. I'm from Durham U. In the area of use and decorum in the rules and regulations, at which time when a board passes a policy and it follows the protocol of becoming an amendment, at which time does the policy become enforceable?
Okay, so if you approve, let's say we amend, okay, and
no, I'm talking about prior to the amendment. The board passes a policy, right?
Okay.
And then it has a protocol to follow. The secretary of the building has to certify it according to my bylaws. The secretary of the building has to certify it. Then it has to be sent to the Broward County for public records, and then it has to be sent to Tallahassee to be certified by Tallahassee before it becomes an amendment. Is that correct?
No. Sir.
Okay, then correct me.
So if you're talking about amendments to your documents, then those amendments have to go through the approval process that's set forth in your documents, okay? And then there's only the requirement to record them with the county. The only thing that gets sent to anywhere else would be if you're amending your articles of incorporation, then you have to file the articles of incorporation, those amendments, with the Division of Corporations.
All right. When we file the policy with the Broward County Board of Public Records, at that time does it come enforceable?
That is the dividing line of enforceability. So an amendment becomes enforceable once it's recorded.
Thank you very much.
You're very welcome. Any more questions? Okay, well, I want to thank you all for having me here today, and I want to thank the CVE committee for working with me so wonderfully. You guys have been wonderful. I look forward to meeting with many of you, hopefully, and I want to thank Bill for helping me out today. So thank you all, guys.